right to counsel in this case, the record must demonstrate two things. The first is that the police deliberately and unnecessarily delayed the arraignment process in appellant's case. And the second is that they exploited this delay for the purpose of obtaining a confession from appellant before counsel entered the case.
Every claim of delayed arraignment constitute a claim of deprivation of right to counsel?
Absolutely it does, Your Honor, and the court has in the modern era, the court held that in People versus Blake and applied the rule of Blake in Lockwood, in Wilson, in Hopkins, in Ortley. Now, the court didn't always suppress, the claim didn't always win, but this issue has always been analyzed as a right to counsel claim by this court in the cluster of cases.
What is the delay that's identified in Wilson, Hopkins, etc., the same as the statutory delay codified in 14020?
Now, because the statute 14020 prohibits any unnecessary delay, no matter what the motivation of it or the purpose.
Your claim, because you got a preservation problem on 14020.
Right. This is not a 14020 claim for us at all. This is a right to counsel claim. 14020 claims don't even give rise to suppression, we would suggest.
If somewhere at a trial, not at a suppression hearing, somewhere at a trial, it turns out that some police officer along the line delayed the arraignment for purposes of interrogation, that in and of itself always will be a even unpreserved, unnecessarily, no need to preserve, you always got the claim.
If the record adequately supports the claim. That doesn't happen very often. In the cases that I've listed where this claim has been applied, it often loses because presumably this deliberate manipulation of the system to deprive the defendant of a right to counsel doesn't occur.
In this case, you address what the unnecessary delay was. Was it inappropriate for the officer to wait, attend the autopsy, and to wait to determine the results of the autopsy in order to determine the appropriate nature of the charges? If
you examine the officer's testimony in that case, the fact that the autopsy was occurring the next day had nothing to do with her decision to stop processing appellant and to wait until a different, in her view, more skilled officer would arrive the next day to elicit a better statement from him.
Record sufficient for us to make that conclusion?
I think the record in this case, it's an unusual record, but I think it could not be more clear. Let's look at what we know from the record. We know that the police formally arrested appellant for murder at 12:20 a.m. on July 19th. We know that by that time, Mr. Ramos had already provided a written statement and signed it and indicated to the police that he did not wish to speak with them further. We know from Detective Brooks, one of the other detectives in the case, that the police viewed the case against Mr. Ramos at this point as open and shut, cut and dried, was the officer's words. We also know that right at the time of the arrest, Detective Toole, who's the assigned detective in this case, from which most of this comes, she started to do the paperwork in this case as she was supposed to do, as the patrol guide required. And she continued to process the arraignment in this case until she read that first statement, and then she stopped. And she tells us why she stopped. She tells us that she knew from looking at that first statement, elements of it didn't make sense. She thought that Mr. Ramos knew more than he was saying, and she testified that she wanted him to be interviewed again.
What's wrong with that?
What's wrong with that is that once someone has been arrested, there are rules, and you cannot say, as...
14020 is not in place, so don't talk to me about 14020. It says no unnecessary delay. You told me this is a constitutional right to counsel case, so let's talk about that. What's wrong with someone who has not invoked the right to counsel, who's given an inculpatory statement, and an officer says, geez, you know, this doesn't stack up? You mean to tell me the officer cannot go and question them again?
What the officer cannot do, maybe if this special detective that they were waiting for was at the precinct, and thus the delay would have been the minimus, maybe. But what happened here is that they stopped processing him. They said, she called the ADA. She said, we're not going to send him over. We're going to hold him here overnight. And we know that Mr. Ramos remained in that interview room at the 102nd Precinct overnight until 1 o'clock the next afternoon when this detective finally arrived.
I understand the statute's out of the picture.
Let me amend that, because
Said the statutes are on the picture.
the unnecessary delay is an element of my right to counsel claim. I have to prove two things. I have to prove the unnecessary delay under 14020, and then I have to prove...
Wait a second, you never moved. You never moved against this under 14020, so you didn't put anybody on notice, because the remedy, as you well admit, under 14020 is not suppression. So that's why I was very clear to ask you that. I presume you understood what I said.
Well, let me
ask
clarify.
you again then. Do you make a claim under 14020,
No.
and is it exempt from preservation?
I do not make a claim under 14020, but the unnecessary delay of 14020 is an element of right to counsel. I have to prove unnecessary delay, plus I have to prove improper purpose. I have
Let's
to
suppose
prove-
that's accurate. Let's suppose we take that as a premise. Was there a motion here to reopen the suppression hearing?
There was not.
All right, now let me just ask you where that leads us, inasmuch as no motion was made. Let's see if we agree with you, hypothetically, that often, but not always, the reason that the police delay arraignment is because they want to have a longer shot at the accused before the lawyer comes into the case. If we take that as a hypothetical, I'm not saying it's true or not, but let's suppose that is true most of the time. Given that premise, why shouldn't the DA then be able to explain that this was not such a time, but that in this event there were other reasons, and that by not making a motion to reopen it, the DA is handcuffed and is not able to explain that in this instance the purpose for delaying the arraignment was not to squeeze more information out of the defendant until the lawyer arrived?
Well, with regard to a right to counsel claim, it does not have to be preserved, but there is an onerous requirement. The record must be sufficient.
But-
It's our position that there's no more to squeeze from this record.
You start out, now you say, as part of your proof, you have to prove an unnecessary delay, apart from the motivation of the police, right? You have to prove objectively there's an unnecessary delay.
And I believe I have...
Now, the question, following up on Judge Rosenblatt, the place to do that should be in the suppression hearing. The DA should not have to try extraneous facts to show separate reasons for the delay in the middle of a trial, should he? Is that good policy?
Except in this case, if you look at the record as it developed, on the narrow facts of this case, we know what her reasons were.
We don't know all the reasons perhaps.
But this was a very pointed cross-examination in the midst of this trial about the delay in the arraignment. They were talking about the patrol guide and her obligations under the patrol guide. And she told them, the reason I decided not to send him over, the reason I decided to stop the booking process was because I wanted him to be questioned again, and that officer would not be in until the next afternoon, as it turned out.
You brought a 44010 motion?
No, the sole question in this case is whether the record as developed is sufficient. It's,
But you're clear, had the DA been soliciting proof about the necessity of the delay, it's ancillary, isn't it?
They said, why did you delay this? And she answered that question. That's what the record...
You have a good cross-examination on an issue you didn't raise for grounds for suppression, and then make a good enough record so that later you can go to an appellate court and ask them to, after the fact, suppress it. It's an interesting technique, but let me ask you, why does the record show the delay was unnecessary when the officer concluded that she thought there were holes in this fellow's confession? This confession was not completely inculpatory. In fact, it was exculpatory, was it
The
not?
initial statement was...
He said that he tried to choke, or he went into her room, saw that she'd been stabbed multiple times, dragged up the stairs, placed in a bathtub, someone had choked her to death, and he went in and he touched her, and then he got scared and he just mistakenly walked through the blood that had his footprints all over the house, the apartment where she was murdered. Right?
The police concluded that the first statement plus the other evidence they had assembled was sufficient to formally arrest the defendant on this charge, and once the defendant is arrested, the right to counsel requires that the arraignment not be unnecessary.
Wasn't there also some pedigree information that was necessary for the arrest? There is testimony to that effect. Say that's not true?
The only testimony about the pedigree is, I went in, for pedigree, I said, how are you? He said, I don't want to talk, and I went out. She never indicated that the reason she decided to stop processing him was because she didn't have pedigree. She said why she decided to stop
But
processing him.
the rule that would emerge from this case, if we take your position, is as long as there is sufficient evidence to arrest and charge the defendant, there can be no delay for the purposes of interrogation.
Not
It's an unnecessary delay.
No, not as long as
A
it...
legitimate delay if the reason for the delay is to interrogate.
No, I mean, the defendant has no right to be arrested, so it's not the fact that sufficient evidence existed. It's once the arrest occurs...
Once he's arrested, if there's enough evidence for the arrest, there can't be any delay for purposes of
Well, he doesn't
interrogation.
have to be arrested, but once he is arrested, the police cannot. This is the rule that emerges from Blake, and Blake recognized that this was going to be a problem. When we make arraignment the key moment in the assignment of right to counsel, the potential for abuse is that the authorities will delay that arraignment for purposes of gathering more evidence. And
You see, this would be a revolutionary change, would have a revolutionary impact.
no, because I think this is an unusual case in this sense. I mean, this is an officer. They started to process him, and they stopped processing him.
Let's try it again. Have an arrest. If it's a legal arrest, there's enough evidence to arrest him. Now, you're saying at that point, if the only reason for a delay is for purpose of interrogation, unpreserved, you get a suppression of the statement because of denial of right to counsel.
If the record is sufficient to negate other reasons for the delay, and I believe that's what we have in this case, and I don't believe it's anything other than an application of what the court has done in the past. In the past, however,
Blake is where you really start out, right?
Blake is where I start, yes.
But Blake has an interesting language. I'd like to read it to you. It says, it talks about the rule, it can't be unnecessary delay, and then it says, in that event, the prosecution would have the burden to explain and offer proof on the pretrial identification hearing, and if one is had, and why the opportunity for counsel was not afforded.
Sure.
Well, isn't there a little bit of a problem there? Blake is premised on the fact that the people do get a shot at explaining the delay. And that didn't happen here, did it?
But there's no there's no exception for the general rule that a right to counsel...
I want to go with Blake with you, and Blake has burden shifting, which in Kinchin says adequate record. I'll ask the Chief Judge to allow you to ask the last question.
I'll allow you to ask the last.
Isn't it true that Blake envisions the burden shifting and the people being given the opportunity to explain the delay?
But Blake does not change the general right to counsel rule, and the subsequent cases apply that rule, that even when a right to counsel claim is not raised in the trial court, it is still cognizable on appeal if and only if the record is sufficient to establish the delay and the bad motivation. In all the cases thereafter, the record has not been sufficient. In this case, I would submit the record is sufficient.
Thank you, Mr. Joselson. Ms. Aldea?
Good morning, Your Honors, and may it please the Court. Defendant's argument...
You agree that the delay was to question the defendant some more?
Actually...
That was the only reason for the delay?
Actually, preliminarily, I don't agree that there was any delay at all, let alone an improper one. And to the extent that the arraignment time took 14 hours as opposed to any shorter period, the reasons for that delay, to the extent that we characterize it as such, was clearly said by the officer she said that she moved as quickly as she possibly could. Under cross-examination, when the defense attorney was attempting to put words into her mouth, he was attempting to have her admit at trial on cross-examination that she purposely delayed the arraignment, and she refused to do so. Clearly said...
Did she say she wanted further examination of the defendant?
Yes, Your Honor, she absolutely did. What I contest is she never said that this was the sole reason.
Okay, that's a good point. Now, other than what might to some people seem obvious and to others not at all obvious, other than the purpose of delaying the arraignment in order to keep a lawyer out of the picture, because the police know that as soon as you arraign, the lawyer comes out of the picture and you can't talk to the person anymore. They know this, right?
Yes, Your Honor.
Other than that
Presumably.
motivation, they know it. Other than that motivation, what can you tell us, in theory or hypothetically, that you would have been able to show at a hearing, had you not been handcuffed, to demonstrate that that was not their motivation? Tell us what could conceivably come out given this record, all right?
Yes,
Here's
Your
your
Honor.
chance.
To begin with, I would rely on some of the things that did in fact come out at trial that could have been more fully developed at a hearing. One of those was the officer specifically said that she had to go to the autopsy. Now, in this case, attending the autopsy was highly relevant to defendant's arraignment because based on the nature of this crime, it was impossible to even ascertain what the cause of death was in this case. This girl had been stabbed, slashed, shot,
6
put in a
times in the chest.
bathtub, drowned. I mean, it was strangled. There was absolutely no way. Yes, Your Honor. And there was no way to ascertain what the cause of death in this case actually was. So that was one reason she absolutely had to go.
To draw the charges in
Yes, Your Honor.
keeping with the evidence.
Yes, Your Honor. That's one reason. Another reason is we have no information as to how long it actually took to complete all of the necessary phases of the processing that
Was
needs
the
to occur.
autopsy complete?
The autopsy was completed, I think she said she attended it at 10 o'clock in the morning, and it was, as soon as it was completed, she came back to the precinct and he was taken to arraignment. In the interim, he had
When
been...
was he arraigned?
I have that information. She did leave at 10 o'clock a.m. She returned at 3 o'clock p.m., and at that point, he was sent to central booking and arraigned shortly thereafter. I don't have the exact time of the arraignment, but he was sent to central booking around 3 o'clock p.m.
5-hour delay.
Yes, but it's as soon as she came back to the precinct. So as soon as she came back after the autopsy, she finished processing defendant, getting his pedigree information, and then sent it to arraignment. Again, another reason, to answer Your Honor's question, is that here it's clear that when she went in to obtain the pedigree information, defendant never told her, never completed giving her the pedigree information that she needed. So she then allowed him to go to sleep for 8 hours, and then had to come back the following day to obtain the rest of the pedigree information. We also have no idea how long it might have taken to obtain his rap sheet after his prints were sent to Albany. We have no information as to any of these things. And finally, just on the point of whether the officer's intent to have a more experienced homicide detective question him was improper, it absolutely is not. There's nothing wrong, there's no requirement in this state by this court or any other that has said that as soon as the police have probable cause to make an arrest, they must immediately stop questioning and send a defendant to arraignment. In fact, what this court's precedent and that of other courts has established is that the police have the discretion to obtain not only the quantity of proof sufficient for a probable cause arrest determination, but also the quality of proof that they feel will get an indictment. In this case, as the court has pointed out, all the police had at the beginning was an exculpatory statement by the defendant. The detective that was the booking detective in this case, Detective Toole, was not an experienced homicide detective. She wasn't even a homicide detective. And she felt that based on the murder in this case, which was particularly gruesome and very complicated, she wanted to have the most experienced homicide detective she knew question the defendant. And that was entirely proper. But, Your Honors, to step back a little bit from the merits, as a threshold matter, we would say that there is no right to counsel that had attached in this case at all. This court's precedent, contrary to defendant's contentions, has never held that the right to counsel can attach before commencement of formal adversary proceedings
Are you
not
saying
invoked.
that the people did not have enough proof to charge the defendant until they got his confession?
I'm saying that the police officer was entitled to determine when she had the quality of proof necessary to obtain an indictment.
Did they have a statement from his girlfriend?
Actually, they didn't have that statement until later, not at the time of the first statement, which is presumably when defendant
When you
claims they
say
had
later,
probable
was
cause.
it before the arraignment?
It was before the arraignment, yes, Your Honor. Your Honors,
Indeed, her statement played it onto him, but indeed also she had some difficulty with this victim, right?
excuse me, Your Honor?
She'd had some difficulty with the victim herself.
Yes, Your Honor.
So it's not so clear that perhaps she didn't have a motive to also
Yes, Your Honor.
kill.
And in fact, actually, one of the reasons, to go back to the merits, one of the reasons that it's important to have the police have this authority to question a defendant more fully is that one of the things they're looking to do is to ensure that the person that they have before them is the person who actually committed the crime. and to try to discover the circumstances under which the crime were committed and if any other people were involved. They absolutely needed to question him in order to do that.
Counsel, what are you asking us to do? Do you want us to find there was insufficient evidence or that there was no unnecessary delay?
Actually, what I would like this court to do is to clarify that that the indelible right to counsel does not attach and cannot attach before an accusatory instrument is filed, before commencement of formal adversary proceedings, unless invoked. In other words, to say that under the Hobson and DiBiase line of cases, this court has already defined the complete circumstances under which the right to counsel, the indelible right to counsel, can attach.
Blake, would that mean?
No, Your Honor. And actually, I'd like to read from Blake. Blake is being touted as the key authority on this issue. In fact, what Blake said, and I'm reading, it's a quote, the summary of the decision written by this court. Blake said, "The presence of counsel at identification viewings is mandated after the filing of an accusatory instrument on pain of exclusion of the identification, except in narrowly exigent circumstances." In other words, Blake says that it's only mandated after the filing of an accusatory instrument.
Except under some circumstances.
Well, Your Honor, let me go on to read that. After arrest, but before the filing of an accusatory instrument, the presence of counsel is not mandated, but is desirable. In other words, what Blake says very clearly is that there is no constitutional right to counsel that attaches before the filing of an accusatory instrument.
What happened is that some of our jurisprudence or some of the appellate divisions have confused Hopkins, which is about voluntariness.
Yes, Your Honor.
Talks about where there's been a delay. Hopkins is all about a voluntary statement. It's a very short opinion.
Yes, Your Honor.
Says, well, delay is in the calculus of voluntariness, but Blake is an attachment case.
Yes, Your Honor.
And your view is that Blake clearly says, till it's filed, there's no indelible right, and that's it.
Yes, Your Honor. And
So
in
your
fact,
rule is so broad, you know, I could understand where you're saying that the DA shouldn't be handcuffed to explain that what some people would say is an obvious motivation was not that motivation at all, but the real reason is to frame the charges through the autopsy. Okay, that might sound okay, but you want us to go further, and you want us to say, to give out a rule, to promulgate a rule by which if the evidence is overwhelmingly establishes, or by admission, what if the detective were to say, yeah, the reason that I wanted to delay the arraignment in all candor was because I didn't want lawyers in the picture. And under your rule, that would not involve suppression.
actually, Your Honor, that's not accurate, and there are two answers to that.
That's not what you're proposing.
Yes, Your Honor, there are
All right.
two answers to that. The first answer is that actually it would require suppression under 14020, which is an alternative remedy, or under the line of cases in which this court has held that under the Fifth Amendment, a confession can be rendered involuntary by the passage of time or an unnecessary
Well,
delay.
then you're into Euclid in 26 hours, you know, or 48 hours. So let's put cases like Euclid aside, and let's say, because we don't know what happened in Euclid, or we're not talking about motivations, but let's say you have a case where the detective candidly admits that the reason for the delay, even for an hour, was in order to keep lawyers out of the case.
Then in that case, I would say that the answer would be 14020, and that does provide a remedy, a suppression remedy in that type of situation. The second answer to Your Honor's question, though, is that essentially all we're saying is that you cannot condition the attachment, not a determination of whether there's a violation, but the attachment of the indelible right to counsel on a police officer's subjective intent. In fact, this court, in other analogous precedent, has held in People v. Robinson very recently that pretext stops also should not be an area of this court's Fourth Amendment jurisprudence. In other words, this court should not look to the subjective intent of the police in trying to analyze whether there was a constitutional violation of a defendant's own personal rights. There is no right more personal to a defendant than the right to counsel. And because the right to counsel is personal to the defendant and is his own, the officer's subjective intention when they're questioning him cannot play a part in whether that right attaches. In fact, Your Honors, this would actually result in an injustice if this court were to adopt this rule, and this is why. In order for this, if this court were to adopt this rule and condition the attachment of the right on an officer's subjective intention while questioning a defendant, two identically situated defendants, both of whom are being held under the same conditions for the same crimes for the same period of detention, being asked identical questions in the same manner, who perceive what is happening to them in the same way, would be treated differently. One of them would be afforded a right to counsel, the indelible attachment of his indelible right to counsel, solely by virtue of an intention of a police officer that's not even known to him, and that plays no role in how he answers the questions or how he perceives them. The other one, in an identical situation, would not have the benefit of that right. And that is what defendant's rule in this case proposes. And that is another reason why this court should make it very, very clear.
It's an identical situation, and what's it, when you say they're two different, one would, so when you say it was identical, they're the same. In what manner is the second person different?
There is no difference. The only difference is the subjective intention of the officer questioning him.
I see. One has the subjective intent and the other one doesn't.
And the other one doesn't. And the subjective
That's the
intent of the officer is an operation of his own mind, not even known to the defendant, who's the one who possesses the right to counsel. That's why it would be so irrational to adopt defendant's position on this point, even without looking to the logic that this court has employed in Robinson, just on a very practical standpoint. Thank you.
Wilson?
Let me just make a couple of points. First, I'm not asking the court to apply a new rule of attachment. I'm simply citing the rule that started with Blake, and I won't read the portion of Blake that I'm relying upon because Judge Wesley already read it and has applied consistently since then. This is nothing new. The motives of the police is standard fare in the right to counsel context. In Cone and Airmo, we talk about purposeful exploitation. There's nothing new or novel about the right we're asserting here. What they're asking for is really quite radical. It suggests that there's a suppression remedy under 14020. 14020 prohibits only unnecessary delay irrespective of motivation. Well, that would be quite a broad suppression remedy that has never been.
But in your analysis, it becomes unnecessary because of the motivation.
Well, that's correct. I think mine is the one with the narrowing principle. The rule that they're proposing, although it aids them in this case, is actually an extraordinarily broad rule.
Nothing in this record that shows that they were trying to keep lawyers out of the case, is there? I mean, he didn't say, geez, I'd really like to talk to a lawyer. Any of the testimony that said, geez, as long as we keep questioning him, we'll be keeping the lawyers out of the case. So there's nothing to say that there's an expression of subjective motivation.
He certainly did not. The trigger for this right is certainly not anything that the defendant said. I agree with Your Honor there.
Are you saying that as long as the police officer says, I want the defendant to be questioned without benefit of counsel, that is sufficient to say that the right to counsel has been triggered?
I think there's one limitation on that. In Ortlieb, for example, is a case where the defendant shortly after arrest agrees to speak to the police, and it took a little while to facilitate that, and so there was some delay. That's not what I'm saying. Here's a case where the defendant had given a statement and said he wished not to speak further. After his arrest, there was no requirement that he be arrested here. They could have gathered information, evidence for as long as they wanted. But once they make an arrest, certain rules apply. That's our position. Let me just comment with regard to the autopsy matter. Based on the recitation of the facts of this crime, the one thing that was not necessary to determine what charges were going to be leveled in this case was an autopsy. It was clear that this was going to be an intentional murder charge. The autopsy had really nothing to do with the charges. What had to do, the delay was motivated by what Detective Toole said it was motivated, was a desire to keep him there so he could be further questioned.
Fernandez against Hammonds.